Good evening. I think we're going to go ahead and get started here. My name is Denise Jorgens. I'm the Director of Programs and External Relations here at International House. International House is pleased to host this evening's program. Tonight's program is part of the World Beyond the Headlines series. This popular public lecture series is a collaborative project with the University of Chicago's Center for International Studies, the Chicago Council on Global Affairs, and the Seminary Co-op Bookstores, with support from the McCormick Tribune Foundation. The program brings scholars and journalists together to consider major international news stories and how these stories are covered. Tonight's program is also co-sponsored by the Center for Eastern European, Russian, Eurasian Studies and Amnesty International. And before I welcome Jerome McDonnell from Worldview to introduce our panelists, I'd like to draw your attention to the next program in the World Beyond the Headlines series, which will be held on Thursday, March 20th, when we will welcome author Parag Khanna speaking on his forthcoming book, The Second World, Empires and Influence in the New Global Order. That will be at 6 p.m. here at International House. Thank you all for coming.
Hi, I'm Jerome McDonnell. I host Worldview at Chicago Public Radio. I'm your host this evening. We've got a great panel here, and it's interesting what a long history the International Criminal Court of the former Yugoslavia has had. And I looked up, I had forgotten the full name of it. It's actually called the International Tribunal for the Prosecution of Persons Responsible for Serious Violations of International Humanitarian Law committed in the territory of the former Yugoslavia since 1991. And everyone calls it the ICTY, the International Criminal Court for the former Yugoslavia. It was created way back when by a resolution at the United Nations on May 25th, 1993. 161 persons have been indicted by the tribunal. There have been proceedings concluded against 111 people, including 9 people who were acquitted. There's now 50 ongoing proceedings, if you include the 4 indictees who are still at large, including Radovan Karadzic and Ratko Mladic. The last indictment the court handed down was March 15th, 2004, and the tribunal aims to complete all trials by the end of 2009 and all appeals by 2010, and we will talk about this closing, this winding down of the ICTY tonight. The ICTY had great achievements, a lot of great achievements. It was the first international tribunal of its kind since World War II to meet. It meant that tribunals, international tribunals, weren't just a one-time deal. It helped establish facts about what happened, really happened in the former Yugoslavia. It indicted and brought to trial a former head of state. This really helps tip the scales from impunity for leaders towards more accountability. The tribunal gave voice to victims, and some were able to directly confront their perpetrators, the people who committed crimes against them in a court of law. There were lots of legal achievements, better definitions of a variety of legal issues with regards to treatment of civilians in wartime. There's chain of command issues, and certainly and notably precedents on punishment of sexual violence in wartime. And certainly the momentum from the International Criminal Court for the former Yugoslavia led directly to the establishment of the Permanent International Criminal Court. On the downside, there's been a lot of critics for the International Criminal Court for the former Yugoslavia. They said it takes too long, it costs too much, and certainly the Bush administration was on that side of the equation. The Hague was quite far away from Yugoslavia, and it seemed to contribute to the region not quite taking ownership of the procedures and outrightly rejecting some of the findings of the court. You notice all the subsequent attempts at international justice, Sierra Leone, Cambodia, they go with more hybrid models closer to home. And certainly there's been lots of questions about the strategies involved, the prosecution of Slobodan Milosevic. And ultimately, a lot of people feel, even people who were enthusiastic about the court at first, think that it fell far short of the lofty expectations that were set out when it started, that justice was going to lead to a degree of reconciliation and peace, and that was something that was essential and was going to help create and pull the Balkans together again. It didn't exactly do that. We are going to delve into the ups and downs of the ICTY tonight, and we've got some great panelists. I will go from the person who will speak last. This is Gordana Igric. She'll be speaking to us last. She's the director and editor of the Balkans Investigative Reporting Unit, and I'll introduce her more fully when her time comes. We have Judge Shireen Avis Fisher to her left. She'll speak second. And appropriately speaking first is Sharif Bassioni from DePaul University. He's Distinguished Research Professor of Law, President Emeritus of the International Human Rights Law Institute at DePaul University's College of Law. He has written, as you notice in your handout there, 27 books. 27 books. I will now read the titles. That's my only joke. That's the only joke. But in reality, a couple that pertain to us are the law of the International Criminal Tribunal for the Former Yugoslavia and Sexual Violence, Invisible Weapon of War in the Former Yugoslavia. Most notably, Sharif was a member and chairman of the Security Council's Commission to Investigate War Crimes in the Former Yugoslavia. It went from 1992 to 1994, and it compiled evidence and brought it to the Security Council and made a recommendation for the creation of the ICTY, which the Security Council took them up on. So he was quite instrumental in the formation of the ICTY. And Sharif, you're first.
Thank you. Thank you all. Thank you. Well, Jerome, you did a marvelous introduction to the topic, and I will sort of base it, my presentation a little bit on it. I don't know how to sort of caution you or alert you to something that most observers of international developments sometimes are not able to perceive what goes behind the scenes. And whenever you are faced with any type of international instrument, treaty, the establishment of an institution, it is not without a great deal of political baggage. And it is not without a great deal of diplomatic negotiations, and it is not really the product of any sound policy or sound legal construction. It is always a compromise work. And the very fact that it is a work of compromise ultimately carries with it the seeds of its own weaknesses, of its own failures. And as most of us look at things after the fact, look at them in retrospect and ask the questions, why was this done this way? Or how did it happen that things went that way? We will be very hard put to be able to understand. And I'll give you a simple example. The whole world has to be asking the question, where everybody is saying there's a genocide in Darfur, let's assume it's not a genocide. I mean, it's pretty bad. A lot of people got killed, irrespective of how you want to call it. Why isn't anything happening? Or, next question, well, the Security Council referred the matter of Darfur to the International Criminal Court. Why isn't the International Criminal Court doing anything? Well, if you read far enough in the resolution of the Security Council, you will see that it also says we will not provide any resources to the ICC in its investigation and prosecution of cases in Darfur. And the Sudanese government says, I will not cooperate with you. And the Security Council says, you really ought to go and negotiate with the Sudanese government, see if they'll cooperate. Ergo, how do you expect the ICC is going to in any way be able to carry out its mandate? Well, the same thing happened in 1992 when the Security Council established a commission to investigate war crimes in the former Yugoslavia. And it had a very long name, as Jerome read the name. Well, you know why the long name. The long name, just as in our case, we were Security Council Commission 782, parentheses 1992, to investigate violations of international humanitarian law in the former Yugoslavia. Nobody wanted to have a punchy word, commission to investigate war crimes, or something that would sort of jerk people into the realization that this is something pretty serious or something pretty bad. You know, you sort of dilute it in the innocuousness of United Nations lingo. And the commission was established, and to my absolute surprise, I mean, I took it seriously. As Jerome said, this was the first step after Nuremberg. And lo and behold, there wasn't a single dollar, shekel, penny, for the commission to do the work. And I said, this can't be. I mean, I couldn't believe it. Well, after 2 months, I came to the realization there was some method to this madness. Of course you wanted to have a commission with the big sounding title and the big mandate, but you're not going to give it the money in order to operate, because at that time, what was the priority was David Owen and Cy Vance negotiate a peace settlement. We were in the height of realpolitik. You can't have a group of people going around investigating Mr. Milosevic, Tudjman, and Izetbegovic at a time when the red carpet was being rolled for them at the Elysee Palace in some of the meetings they had in order to sign a peace agreement. So in the minds of the realpoliticiens, justice and peace were at odds. And so it took a great deal to sort of end run the system, get the resources, do the investigation, and, you know, lock horns with the politicians, diplomats, officials to get the evidence and then dump it on the Security Council and said, you cannot ignore it anymore. So the Security Council establishes the tribunal. But in establishing the tribunal, again, you have to start looking at these things as people who are interested in world events. The reality is the realpoliticiens of this world have now know how to play the card of justice. They know that international civil society wants justice, they want accountability, they don't want impunity, they want to make sure that the truth is being told about these conflicts. So, knowing that, how do they go about preventing it? Well, they go about preventing it bureaucratically. You don't give resources to the institution. You make things difficult for it to work. The same thing as in Darfur. The Security Council gives the mandate to the ICC. The prosecutor says, I'm willing to go. Well, he doesn't have any money. Well, okay, go cooperate with the Sudanese government. Sudanese government says no. He goes to the Security Council, says, give me sanctions against the Sudan. Oh, no, we can't have sanctions against the Sudan. You can read your own political reasons as to why the U.S. doesn't want to give sanctions, but that's the point. So the same thing happened here. No resources to the Commission, etc. Then we established the ICTY. Magnificent. So the ICTY is established. The Commission continues its work, but there's no prosecutor. Then they pick up a prosecutor, the UN bureaucracy, knowing full well, a Venezuelan, that he was not going to take office. So he fills the chair, but he's not there. So the work doesn't get done for a year. The second one, they pick up somebody from South Africa. He's a commercial lawyer who turned out to be a commercial judge, knows absolutely nothing about the situation. By then, the commission is closed. And so there's a gap. Well, I reach out for the South African, and I called him up and I said, you know, I need to help you and you need the help. And he said yes. And so we end run the system. And when he arrived in The Hague on a Friday, I arrived on Saturday, and we went in his office on Sunday. He had a beautiful office, all white, white furniture. Struck me. And I said to him, do you have a map of the former Yugoslavia? He called the staff, and no, they didn't have a map. So they put up a map like this one. I'm sure it's probably a little older than this one. Does this one have Slovenia on it? Yeah, just up in the corner there. But it still has Serbia and Montenegro. Anyway, it was a map that was pretty old, out of date. And we started talking. And I said, well, do you have any idea what's happening here? He said, I have no idea. I said, do you know how many countries are fighting? He said, I didn't know there were that many countries. Do you know how many official warring factions there were? At the time, there were 6 formal armies. How many paramilitary groups? Well, we had 89 paramilitary groups. And so suddenly all of these facts came. My God, how am I going to do that? So we both run the systems because we both were committed to the same purposes. There was no ego games here. And I passed to him all of the evidence that I had, about 76,000 documents and 300 hours of videotapes and 3,000 pictures, and things got started. Now, just to illustrate again the point of the difficulty, the prosecutor, Richard Goldstone, started his work, and then on one day he found out the Security Council decided to make him chief prosecutor of the Rwanda Tribunal, the ICTY. So here's Goldstone, you know, having a heck of a time just finding out what's happening in the Yugoslavia, and now he's chief prosecutor in Rwanda, and there's a big, big distance between The Hague and Rwanda, believe me. And so he accepts the challenge, and true story. So he writes to his, I call him his control, the guy whose job was to make it impossible for him to do things, who was also my control and whom I fought against. And he said, well, I need to go to Rwanda to find out what's happening. And he said, well, gee, I'm sorry, we don't have the money for you to go to Rwanda. He had to go to the Secretary General to get authorization for $4,000 to buy a ticket to go to Rwanda, the chief prosecutor. Okay? So anyway, now we finally have a tribunal. And the tribunal is operating with all of the difficulties. And so what's the new process of co-optation? Drown the tribunal in bureaucracy. No hires can be done other than through United Nations bureaucracy. And, you know, United Nations has this great, great talent. It has accumulated and assimilated the worst bureaucratic practices of the world and merged them together into one ideal practice in the United Nations. And in that, it has created a magnificent melting pot. You have no idea of the twists and turns that take place in UN bureaucracy. You know, it's beyond belief. Anyway, so the tribunal is now overcome by the bureaucracy, overtaken by the large staff. I think there's 1,000 people working in the OTP's office. And things are very cumbersome. And if they're cumbersome, they're costly. And if they're costly and cumbersome, they're going to be slow. And if they're slow, cumbersome, and costly, we can criticize them. And then after a while, we can say, look at how much it costs. Look at how long it takes. It's now time to close it. And here it is, now closing it. First decision was 208, second decision maximum 210. Lo and behold, something extraordinary happens, and the something extraordinary is the establishment of the special Bosnia-Herzegovina court, which is in fact to be the successor of the ICTY. Now, never before have we seen an ad hoc tribunal think and plan of a successor institution to take over. Usually that's it, that's the end of it, you know, put your stuff in an archive and let historians and students write dissertations about. And so there it goes. But now we have something that's coming over and is going to pick up what is there. And that is an extraordinary development in the field of international criminal justice, in that an institution like the ICTY, which is ad hoc, is not going to stop from one day to another. There's going to be continuity. Its cases are going to be picked up. There's already a transition. The ICTY's Rule 11 bis authorizes transfer of cases. Cases have been transferred. Some cases have already developed. The new tribunal in Bosnia-Herzegovina has a number of international judges as well, so it's a mixed institution, but it's a national institution. So the criticism of the Yugoslavia tribunal being in The Hague and not connected to the territory is removed. At the same time, the appearance of judicial propriety is preserved by having the international judges as well as the national judges, and the process is moving along. In addition, it will become, I think, a model for the principle of complementarity, which is embodied in the statute of the International Criminal Court. Give priority to national institutions if they have the capability of prosecuting, and only in the extreme cases take on the cases before the ICC. So in a very short nutshell, this is a little bit of the background where we are now, and I think Judge Shireen will tell you how this special court is functioning and the extraordinary results they've accomplished in a short period of 3 years. Thank you.
And that leads us right into Judge Shireen Avis Fisher. She was appointed to Chamber 1 and Chamber 2 of the Court of Bosnia and Herzegovina in 2005 by Patty Ashdown, who was at the time the UN-EU High Representative. And she's from Vermont. She's in 1985. She was the second woman in Vermont history to be appointed to the state trial bench. Since 2003, she's been a part-time lecturer in international law at the Faculty of Laws at the University College of London. And Judge Shireen was telling me what Chamber 1 and Chamber 2 means. And it means one is conspiracy. What is it? Criminal
One is war crimes.
One is war crimes, and one is conspiracies?
Organized crime.
Organized crime. Don't forget, we have cards, and we're going to take questions by card. If you could jot down your questions on the card, and people will come, they'll bring them up here, and we'll ask the questions as when we get to the question and answer time. And here's Judge Shireen.
No, that didn't work. Okay. That is where you will get the information that I will not have time to tell you about tonight. The first is the court's website, which lists all of our cases, verdicts, indictments, histories of the cases, histories of the court, pictures. The second is the registrar's office, which has the reports, which have the financial background and a lot of the history of the development of the court. I want to thank Professor Bassioni for setting me up to talk about the court in the limited time that I have. It really is all about legacy. We are the legacy of the ICTY. And all of the stumbling and politics and problems that tribunal has suffered from, we have the advantage of learning from that experience. In 2005, January, we opened our doors as a war crimes chamber. When I speak about war crimes, I'm really talking about crimes against humanity, war crimes, and genocide. We are a unique court. We are the only court ever that anyone's ever been able to come up with which has jurisdiction to try those cases within a purely national structure. We are a permanent national court which has within it the expertise of international judges and lawyers working together with national judges in order to interpret a brand new package of laws that was passed specifically so that we could try these cases and that we could try them in harmony with the ICTY. The court has benefited not only from the expertise and the problems of the ICTY, but also much of the personnel. Many of the people who founded our court, who were the experts, the international experts in administration, came from the ICTY and experienced the many frustrations that you've just heard about. And because of that, we were able to take several shortcuts. And as a result of that, our record in terms of trying cases more speedily, more efficiently, and considerably less expensively is quite good. In the 3 years that we have been in existence, we have rendered 21 verdicts, which involve 24 different defendants. We have pending in front of us at the present time cases involving 54 defendants. Those are cases that have either been indicted and are waiting pretrial, that is, are within 3 months of trial, or are actually at the trial stage. The way that our court works is that we sit in panels of 3 for trials. There is a national judge. There are 31 national judges altogether on our court and 17 international judges. There are 5 war crimes chambers. We sit with 1 presiding judge who is a national judge, and 2 international judges sit with that judge. As a consequence of that, the appearance of justice, we feel, is preserved. Our court has its own political problems. In addition to the problems that we have had with the ICTY and the UN bureaucracy, we also have to deal with the problems of being in the locality. Now, bringing justice home to Bosnia was important, and you'll hear more from the next speaker about what that has meant in terms of public awareness and the sense that something is being done in the location where the crimes were committed. But it also has the disadvantage of carrying on the sentiments in a very real way that inspired the war to begin with. Sometimes I feel as if the war is continuing in my courtroom every day. Both the witnesses and the victims and the accused still are coming from very much the same places that inspired the original crimes. And one starts to despair as to whether or not the legal solution will ever actually bring reconciliation. And in the process of my despairing about that, I was very much heartened by a national friend of mine who said, we are never going to convince the generation that went through the war that this process, no matter what we do, is going to reconcile us. However, we may be able to tell our children who ask us, what did you do about all of this horror? We can say, look, this is what we tried to do, and we tried to do our best. And that's really what we do every day. The 5 panels that are sitting on these cases, my panel, I'm an American judge, obviously. My international colleague is a Dutch judge. Our national presiding judge is a Bosniak. He's a Muslim. We have a Croat who presides over the 2nd chamber. We have a Serb that presides over the 3rd chamber. We have someone who calls himself Other, who presides over a 4th chamber, and another Bosniak who presides over the 5th chamber. And the impulse is that whenever a person of another ethnicity is being tried before a chamber of a presiding judge of the different ethnicity, the impulse always is, if they are convicted, to say that that person was convicted unfairly because of bias. The role that we play as international judges is that we can be pointed to and it can be clearly said, we are not of any of those ethnicities. In fact, having lived in Bosnia for 3 years, unless somebody tells me what their ethnicity is, I have no clue as to what it is. And I still haven't figured out what the differences are, but which is good. That's the way I want to keep it. The other thing that the internationals contribute to the process is that the package of laws that was put together to harmonize with the ICTY and also to process these cases and the cases throughout the the entire country of Bosnia, are brand new, and they're hybrid laws. And by that I mean a committee put together the law, taking from it what they hoped was the best of the civil system, the adversarial system, and the former Yugoslavian system. And what has, one of the contributions that we have made, being judges from all of those systems, is that since every issue that arises is an issue of what lawyers call first impression, we have been able to put our combined expertise together to try to come up with a jurisprudence that is both purposeful and that has some internal integrity, coming from our own areas of expertise and explaining where those concepts that were pulled from those various pathways, what the purposes were, and how we can preserve those purposes in a coherent system that is purposely Bosnian and not one of those three. The court itself we're very proud of. It was put together in terms, international terms, on very little money. The entire project from the first nail until December 14th, 2009, which was the span of the donor's budget, is 40 million euro. That sounds like a lot of money, but believe me, compared to all other international or internationalized courts, it is not. And I will show you some of, well, just to describe it briefly, we have 8 courtrooms, 6 medium size, 2 large. 1 is high security. The high security courtroom and the other large courtroom can hold as many as 12 defendants with 2 lawyers each. I am sitting on a case with 11 defendants and 22 defense lawyers and 4 prosecutors, so you'll see that in a minute. It's large. We have all of the technical equipment that the ICTY does, and then some. We have all kinds of facilities to assist on witnesses and victims. We have 5 psychologists that are on staff of the court that do victim support. In the year 2007, they helped and supported over 700 witnesses who testified in the war crimes chamber, and over 150 witnesses that testified in the organized crime chamber. In addition, we have police protection for another part of the witness protection program. We have audio-video tapes of our record. We don't have written transcripts, but everything is on digital CD, so that we have a complete archive of every trial that we've done and every preliminary proceeding that has occurred. And we have simultaneous translation. The 2 languages are the local language, which is the official language into which everything must be translated, if it is coming, for example, from the ICTY in English. And English is the other language. And so we have simultaneous translation in terms of all court proceedings, and consecutive translation in terms of our deliberations. Now, if I can get this to work, I can show you. This is one of the large courtrooms. The back row is where the judges sit. The front row is where our court officers and legal staff sit. And the backs of the seats there are for the litigants. This is the high security courtroom. As you can see, we've got computers at each of the tables. Not much, but some of our witnesses we do through video links to other countries, and also in some protection issues arise, and we have a separate room from which we telecast, sometimes with face and voice distortion, protected witnesses. We also have a way of projecting evidence so that each console can bring up the evidence right in front of the attorneys and the clients. Whoops. It's another shot of this is bulletproof glass. You're looking at it through the gallery, the visitors gallery. That's on the other side of the glass. That's a small courtroom. That's looking down from the video control tower down at one of the large courtrooms. That's our library. That's one of our witness waiting rooms. I think this was a press briefing. The young man at the end of the table is typical of many of the people that work at the court. We have a very young staff. They're lawyers. Many of them were trained in Europe. He was trained in Australia. He's a returnee. He left during the war with his family, was educated abroad, and has come back to work with the court. He is our court manager. He's brilliant. And sadly, he is so brilliant that he was invited to Cambodia to talk to the people there about setting up their special chamber, and they liked him so much they've stolen him from us. So the UN now has him, and we miss him sorely. But he's been replaced by a very competent person as well. Whoops. This is one of the rare pictures we have. They usually don't let us take out pictures with the judges in them, but I wanted to show you this. The judge on the far left is an American judge that I worked with. He has since moved on. The judge on the right is a Belgian judge who I actually share an office with, and the judge in the center is the national judge. And I think that's it. Yeah. Just one final point I wanted to make in terms of legacy. In order for our court to continue, what we are going to have to do is to have adequate access to all of the material that was taken by the ICTY as evidence and taken out of Bosnia and needs to come back to us in some usable form. And one of the things that you may be interested in looking at in the future in terms of news is what occurs when the ICTY does shut down and what they do in terms of the archives. We have a great interest in it in terms of the evidence and keeping it in an accessible and usable form for court. But as academics and scholars, you all should have a pretty good interest in it as well, because that's material that I think will provide a few hundred years of research material for some very interesting probing into not only what happened during that war, but perhaps even what caused it. Thank you.
Thanks very much, Judge Shireen Avis-Fisher. I feel like I've been there. Next and finally, we get to Gordana Igric. She's director and editor of the Balkans Investigative Reporting Network, and you can take a look at the Balkan Investigative Reporting Network online. It's a terrific roundup of independent news from all over the Balkans. You should check it out. It goes by the acronym usually, BIRN, BIRN. And Gordana is the director and editor of that, she calls it her baby. And Gordana's done a lot of terrific reporting over the years from the former Yugoslavia. In the 90s, or the early 90s, she worked with the Alternative Information Network and got news into besieged Sarajevo after years of news blackout there. She's worked as a researcher for Human Rights Watch and reported evidence on some of the worst human rights violations. In 1997, she won the Overseas Press Club Award for the CBS news piece In Plain Sight that documented how Serbian war criminals indicted for the systematic rape of women and girls were living in the open without fear of arrest. She ended up fleeing Serbia for a number of years after her reporting on Kosovo, after her life was threatened for her reporting on Kosovo. She's now back in Belgrade after a number of years, and it's great to have you with us, Gordana Igric.
That does seem official for a journalist. When I started preparing for this event, first I hope that the map is back, yeah. I looked a little bit in each country that somehow relates to ICTY. I had some cases, and which I would expect that ICTY had impact on the public, on media, on life of the people, especially on the political structure there also. And then I realized if I start actually digging deep into each country that is so specific in a way, you are going to be overwhelmed with the cases, with the names, new geographic names, and we will lost in the details. So I opted for a quite risky approach to simplify things for you and just to pick what really could be pulled up as a common issue across the region, across these 5 or 6 now countries that appeared out of former Yugoslavia, but somehow in relation with ICTY had something in common. And I also dared, I hope I have enough experience to do it with some authority, to group these issues in kind of positive and negative, exactly as Jeremy was mentioning, and explain what was actually good from the point of civil society and media, independent media, and what could be seen as a failure. So as first good and obvious thing is that actually big war figures are not anymore in the region. They've been charged, they've been indicted, they've been arrested and removed from the political life of those countries. Not that just because of that those countries became less nationalistic or more democratic, but some space is open for new voices, less fear, less control from one power, from one center, thanks to that. Just imagine having Milosevic still there, we would have quite different situation now with the Kosovo becoming recently independent. That's kind of obvious. Also, during these wars that I covered from Croatia, Bosnia, and then Kosovo, and then Macedonia, let's not forget Macedonia in 2009, it was obvious that pure existence of the ICTY was in a way discouraging the crimes as they were ongoing, these wars. And I remember, for example, my non-government at that moment, Milosevic, was quite differently behaving in Bosnia and then later in Kosovo. Although huge destructions were happening in Kosovo, much less bloodshed, slaughtering all the villages, paramilitary units relatively under control. So there was already fear that he might be indicted. And in Macedonia, I was actually in 2001 there was already spread fear across the Skopje, oh, let's not do it because somebody is going to be charged. So in a way, it had that role, ICTY, as something there, independent, that could actually punish if this continues. This is fantastic, I think. Maybe less people died just because of that. Another thing which I perceived as a positive is because ICTY did succeed with a lot of struggle to force all the states that were involved in the war to deliver the documents. There were different levels and the pressures on those states, but still these documents are actually there. And I would not go so far that it helped at all to reconciliation and peace, because it didn't, not yet. But still knowing that these documents are somewhere there and could be then transferred later in the Balkans, in some of the countries, I think it probably would be Sarajevo on the end, although there is some struggle where these documents should go really, still now in the region. It's the fact that maybe some journalists, some younger generation in future could just go there, use it as something which is really dossier to report on, and when the passions are a little bit calmer than they are now, and they are still quite there, maybe that would be something that journalists would be able to break, that concept of ethnic hatred. When I asked different journalists that cover judiciary in the different countries that I'm somehow involved with this job in Bern, and we are present in 9 countries, everybody said that the biggest actually impact that ICTY had in society positive was that establishing some kind of standards, judiciary standards, that are now could be seen in the local courts. And Sarajevo court is not actually the only one, it is the specific. But let me tell you, in Croatia and in Serbia, you have now chambers working independently and putting on the trials actually own criminals. And it seems like that there are not too many complaints how this standard is still coped with. There are a lot of different smaller issues like, is everybody charged? No. Big fish, are they put on the trial? No. But the fact is that these local trials have much bigger impact now than ICTY ever had. They are on the press, journalists report about that, it's demystified because it's not anymore conspiracy of some foreign powers. You can see the witnesses, you can see the there in your own court. And that's probably, I hope, long-term achievement of ICTY, although with a big reserve, what is going to happen with these countries in long term? Are they going to be able to sustain power and independence of those courts without some serious really control from outside? Which I am going to finish pessimistically, as usual. This is what I would see as something which is really achievement. And then we come actually to the failure. Biggest failure could be put in one sentence: a lost media war. Completely failed to convey the message that the crime is individual. It's not about nations. Why did it happen? Definitely today, when you read the newspaper, talk to normal people even in Bosnia, they would completely not understand what was behind these sentences, because these sentences were just picked by the local media, always politically or ethnically established, and then commented by local media in the light of course, we are the heroes, we have our heroes, which are the war criminals of other nations. So it's overwhelmingly across the region presence. Big confusion. Big confusion is now and misunderstanding what really was behind the sentences. Always twisted, given spin to the articles coming from The Hague. Part of that is fault and failure of ICTY not having really media strategy, but knowing how difficult, with what difficulties they faced in organizing, even if they did have. It was almost impossible to bring kind of truth to the countries that are in transition, that still have the same forces in power that they had during the war, although maybe commanders are not there of the army anymore. We are dealing actually with the societies that are very polarized, still nationalistic, still very, memories are still fresh, and because these transitional societies didn't let still go of the judiciary or of the media, we do have a problem of always this twisted information that suit only one nation. We are victims and the others are perpetrators. And even in the cases like in Kosovo and in Bosnia, especially with Bosniaks, if ICTY sometimes knows to be perceived as somebody, some institution that tries to establish false balance. That's the cases when actually somebody from their nation is indicted and charged. Because why? We were victims, and if we were defending ourselves, we couldn't commit a crime. Not mentioning on the other side Serbs who actually committed the most crimes, and they are overwhelmingly they're charged more than the others. So in that way, it's obvious that they think it's only established to punish the Serbs. Overwhelmingly is seen ICTY as a political tool, and that's actually the biggest failure. Although I don't see how it could be avoided, but the fact is that the European Union conditioned accession of all these countries and improvement in that reforms by actually collaborating with the Hague and delivering criminals necessarily led to that point that countries had been perceiving that as a blackmail, as a political tool to give on heroes for the sake of improving and having progress. Especially in Croatia, giving generals meant really that you are punishing us and you are blackmailing us, and we couldn't commit the crime because we are a defending country. Not mentioning Serbia that refused actually to deliver Mladic and support Karadzic, and is now turning back actually to the European Union and going toward Russia. Canada Ponte and prosecutor in general was perceived in each country as somebody who is a really political figure. Even in Kosovo, when their commander was charged, at that moment there were big protests, and all civil society groups actually protested against ICTY. So quite unpleasant public perception that it is not something which is independent, it is basically politically motivated court. It's going to take a lot of time, and maybe 1 decade probably, to move that, to somehow nullify that perception, especially if the local courts then take over and succeed to move further. Maybe it's an interesting point to make is that need to face the past was partly also stimulated by international figures and the presence, especially in Macedonia and I think in Bosnia. At a certain point you could feel that they were sending the message, well, let's look forward, let's not dip too much, let's not point into the people, this is for the sake of the peace. And somehow these civil society groups that were dealing with the issues of the war crimes became weaker. I was witness a year ago, 2 years ago, money, donors' money, government money was started pulling out of these NGOs that were dealing with these issues and supporting the ICTY and supporting the that issue in general and activities. Now is the question, and this is what I'm going to finish with this speech, is that society is now ready really to basically handle long-term all these issues? When you think that the ICTY is going to be closed, that the judiciary is not independent, that media is still very emotionally and financially attached to different political parties and ethnic groups, and when civil society was not given that strong push to take over and go further. Maybe I'm too pessimistic now because I'm coming from Serbia at this point, which was quite kind of revived my memories of the 90s. Recently we had quite big protests and burning American embassy between the others. With the same slogans as it were in the 1990s. It's not the same society, but still it does remind a little bit of that time, and also new generation appeared, which actually is quite nationalistic and doesn't have a clue what happened because media never informed them what really Serbian army and soldiers actually committed and did in Bosnia or in Kosovo. So this is the issue of what kind of steps maybe international community should take to basically keep some kind of presence and control as possible, and if possible, some kind of movement there toward the justice. And these small seeds of judiciary that started developing independent to breed somehow and nurture. I don't have a really now good vision to explain what I am expecting, but yes, there are not stable societies, we don't know what could happen, and as such there is no guarantee for the media and judiciary freedom.
Thanks very much, Gordana. If you have your cards, if you have written questions on your cards, if you are thinking up one right now and want to pass it to the center, and we'll bring those up, and I'll ask a few questions first. This is the fun part for me. I enjoyed, Gordana, hearing you talk about it as a political tool and how most everybody looks at the ICTY as having been a political tool. Judge, do you get that feeling? I mean, do you say, well, the ICTY was a political tool? Do you get the feeling there's any difference for you in Bosnia? What does that feel like when you're out there on the street shopping for groceries and tell somebody what you do for a living?
Yeah, the court is a political football, absolutely. Fortunately, even after 2 years of studying Bosnian language, I still haven't learned it. So I don't have to read some of the things in the press that Gordana is talking about. But everything that we do is cast in ethnic terms, is cast in biased terms. Of the national judges on our court, I told you there were 31 national judges on our court, 5 of them have had heart attacks. They report to me that they can no longer walk down the main street of the town without getting slurs. And it doesn't matter which ethnicity they are. There's enough to go around for everybody. It is very definitely a very vulnerable institution, and it needs a lot of international support, financially, but also scrutiny, and it needs a longer transition period than was originally thought, in my opinion. But we cannot abandon it at this point, because if we do, as Gordana indicates, the political situation is so unstable that all of the progress that we've made and all of the efforts that we've put in could easily be lost if the international community stops paying attention.
How does anyone feel about the argument that the International Criminal Court for the former Yugoslavia was really an impediment to reconciliation? Do you think that the requirements, you've got to turn over this guy, you've got to turn over that guy, we're not going to release this money, or you don't get these visas, or there's all sorts of issues that were kind of stuck and added on there, and did it really end up impeding the immediate reconciliation of these areas? I mean, economically, things could have been a lot better, a lot more together, possibly, if things were different with the indictments. Gordana, do you?
I mean, I really don't think that ICTY had any choice, because can you imagine any society at that point being ready to put on trial own war criminals? They would never ever be put on trial or face any punishment. And the fact is that only way how cooperation actually was extorted from the states was actually blackmail. So there was an issue of doing that like that, or not doing at all anything, and leaving all these war criminals walking on the streets and threatening civilians who would never then come back to their own land. So I really don't see what was the really choice to be made in that sense. But there were cases that that was not kind of, justice was not given, at least it was perceived in the countries the same way, in an equal way. Poor Macedonia now, let me give you the case. They consist from Albanians and Macedonians. When the conflict happened, Hague took four cases in The Hague. What happened really is they charged only one, Macedonian, and returned 3 Albanian cases back. And guess what? The rebels who were leaders at that point, Albanians, they are now in the government. So now you have the situation that the government has to agree, Macedonian-Albanian coalition has to agree to charge Albanians, who actually are led by the same people who are in the government. What's going to happen is destabilize Macedonia. It's going to bring a stress there. So this kind of things, up and down, different cases, actually did almost have a damaged situation, and then helped reconciliation there.
Sharif, do you have any thoughts on that? I mean, this happens every time there is an International Criminal Court case now. You know, is it messing up in Uganda, or you know, if you intrude yourself into Uganda, are you destroying reconciliation? This happens every time down the line. It's always going to happen.
Well, I would agree with Gordana. If you are going to go with a legal solution, then you have to enforce the powers that allow that solution to work. And if some of those seem high-handed, that's what contempt power is all about. There's a certain attitude of arrogance, I think, that the ICTY displays that may be gratuitous and unnecessary, that may, to some degree, interfere with people's feelings. But basically what they have to do in terms of the theory of primacy is they have to enforce their orders. And if they don't do that, then they might as well go out of business. So once you accept the legal solution, and there are other solutions, we're just talking about the legal model. Once you accept that, then you have to use the powers that are necessary to implement it effectively. And that's going to hurt people's feelings, but there you go.
international criminal prosecution has always had a political dimension to it. And most of the time, it started off as a compromised product. Nuremberg and Tokyo were, as Germans and Japanese who were prosecuted before it, considered to be victor's vengeance. So it was not a perfect institution. That is not to say that the people who were tried before these tribunals didn't deserve or merit being tried. It doesn't mean that the judges were unfair, but the perception that it created was one-sided, that only the victors would be excluded and the defeated would be tried. How could you go and sell to the Japanese people the legitimacy in the ethical, moral sense of the prosecutions of 28 senior Japanese officials by a leading government which had just dropped 2 atomic bombs on totally civilian targets, which had resulted in the killing of 200,000 civilians, after the bombings of Tokyo and other cities where there were no military targets. Suddenly, it is difficult for the Japanese people to say, oh yes, our military and political leaders were terrible, they committed all these terrible war crimes, but what about those who committed similar war crimes? Move on to Germany. Needless to say that Germany committed terrible things during World War II, but does that any way wash out the firebombing of the city of Dresden, where in 24 hours 35,000 civilians were killed by burning? And why would people who ordered that be exempt from it? Now, these are the sort of the high water mark of international criminal institutions. As you go down, you start seeing one of the worst examples is the Cambodia Special Chamber. How many people will they prosecute? Probably 3 people. Why weren't they established at the time when the senior Cambodian leadership was still alive and they could have prosecuted? Well, because it was not politically opportune. Will that leave a sense of legitimacy in the people's mind? What sort of legacy will it leave? Will those who will remember the 1 to 2 million estimated people killed in Cambodia, 40% of the population, the trial of 3 old men is going to counterbalance that? You know, former Yugoslavia, in all of these territories here, these are very spirited people. They're very animated people. They're very lively people. They're contentious in every possible way. When you sit at a dinner table and everybody is having a great time, they're fighting with each other. They have this great zest for life. There is no way that in their perception, these institutions are not going to be institutions that they're going to consider questionable. And they're going to say, well, what is the legacy? And frankly, they're right. You know, why do we have to put the ICTY in The Hague? Why did we have to try these people by international tribunals in so many places? Think of Rwanda. Why do we have the tribunal in Arusha? You know, if you're a Tutsi victim, unless you have CNN, and CNN on occasion reports about the tribunal in Arusha, when do you have a feeling that justice is done? If you're a victim, how do these institutions bring you a sense of closure? Notice how these institutions come and go to achieve political results. Saddam Hussein, What did the tribunal prove? On the contrary, it was so botched up that in the end, this terrible tyrant became a martyr because of the way in which he was hung. So there is a fault there. And so that's why international civil society is saying the International Criminal Court is the answer. Enough of these ad hoc things. We need a permanent institution that works on a permanent basis. Now, watch as the ICC progresses. Watch it now, assess it 8 years later. Has it met the expectations of the international community? And the answer is no. It hasn't met the expectations. Institutions at the international level will not meet the expectations so long as realpolitik is going to be stronger than the sense of accountability in the commonly shared values of the international community. When we are going to redress this imbalance and we are going to say, no, justice is important, it is more important than politics, then it will work. If not, we're going to say, as Jerome said, you can't indict these guys from the Lord's Liberation Army because we need them to sign a peace agreement. So now you, ICC, are an impediment to peace because you want to prosecute these terrible criminals, who are just willing to sign the peace agreement. So suddenly we're taking those terrible people who have committed so many crimes and put them in the position of peacemakers. And the ICC as being the bad people who are so, obsessed with justice that they absolutely need to prosecute somebody, and they're standing as an impediment to peace. So you are absolutely right, but it's a bigger issue than those of us in international civil society who want to advance the goals of justice simply because justice is not yet part of the goals of international politics. And it's not so because governments do not make it so.
Gordana, did you want to respond to that?
Just I wanted to mention a very, very typical case. You would remember, maybe not. I don't know how familiar you are with the war. But I remember 4 years Sarajevo was under the siege. Serbs were actually with a sniper hitting civilians 4 years. We had even Srebrenica genocide, literally 8,000 young boys and men slaughtered. Milosevic was not indicted. At that point, I was quite emotionally attached to the issue, and I asked one investigator, well, why he's not indicted? It's obvious. And he said, well, big powers actually don't want to open documents for us, secret services that have enough documents, because it's not political moment, because they still expect him to be peacemaker, as he at a certain point have been. So the moment when actually happened Kosovo, when these big powers, I think America as a leader, decided it's an enemy and has to be bombed, Serbia, suddenly he was indicted, and then suddenly all these documents appeared. We cannot say, we don't know actually, because the man died in the prison without being sentenced. But that was really politically motivated, not to charge him and then to charge him at certain points.
Excuse me for interrupting, but let me give you a small example to prove your point. When I was chairman of the commission and I sought evidence, the U.S. government offered me evidence, and I said, sure. And they said, well, but in order to get the evidence we have, you need to have a top secret clearance. So I said, okay. So they sent somebody who investigated me, and after about a month and a half, they said, you have the top secret clearance, now would you come to Washington? I came to Washington. They said, well, you've got to sign this. And being a lawyer, you learn the first thing, you don't sign anything until you read it. So I took this piece and I said, what does it say? Says, well, you pledge that all of the documents that we give you are only for your eyes and that you will not be able to use them unless we authorize you. And I said, what good is it for me to have it if I can't use it unless I'm authorized? So I was still naive enough, and I said, well, okay, what if I discover things on my own? And can I use them? And they said, Well, but if it turns out that what you discovered on your own is also contained in what we have, then you can't use it without our permission because of the similarity. So I realized that it was a ploy to trap me. I went back to Goldstone later, and he did, I don't know if he did it by naivety or else, but he did sign the same agreement, which I refused to sign. And so for years, he could not use anything that was without American approval. When Milosevic attacked Kosovo, that's when it turned. If Milosevic would not have attacked Kosovo, he would have probably still been president today. And he had the approval and the support of everybody. He thought he could get away with it. And in fact, when he was indicted for the killing of 38 people in Pristina. And that was the only thing, the only thing. I mean, here I had accumulated evidence, what she says. In the annexes to our reports, I documented on a daily basis for 4 years, daily basis, the number of shells falling on Sarajevo, the number of people killed, the number of people injured, the number of targets. I can tell you the civilian hospital, the Kosovo hospital, was hit 231 times during that period. 70% or more, it was hit during the hours of 12 and 2. Do you know why? Because this was visitation times. Because the hospital didn't have any resources. People brought in whatever was needed for the patients in the hospital. And the bombing of the hospital, and the only reason I knew it is because I was there on one day when it was being bombed, and we rushed into a shelter, and I said, well, why is it bombed at this hour? And they said, well, it's always bombed at this hour, you know, so people don't come and do it. What I'm trying to say is the evidence was there. It was never used until Carla Del Ponte, the third prosecutor, was authorized to go after Milosevic. The first indictment was 38 people killed in Pristina, and it was conditional upon the United States providing evidence captured through the National Security Agency by apparently listening to a conversation in which he had given the order to kill these people. And then at the last moment, they didn't give the evidence. The prosecutor then was forced to ask 6 months extension to amend the indictment. She amended the indictment twice to reopen these old cases. Until then, 2 prosecutors had passed. Never was he indicted. There wasn't even a file opened. And you know, I know that there was evidence there because I had turned it in. So this was a quid pro quo for signing the Dayton Agreement. And so in exchange for Dayton Agreement, he got a pass, except that he went beyond that. This is the problem with ad hoc institutions that are manipulated for political purposes. Yes, they accomplish an important purpose. Yes, they produce a little bit of justice. More importantly, they are stepping stones. More importantly, they allow those of us who work in the field to say, okay, we have a precedent, we're going to build on it, the next one is going to be a little better, the next one is going to be a little better.
All right, here's a question about stepping stones. What legal precedents, if any, did the ICTY set for current conflicts today that we see? And this person mentions all the hard ones, Israel, Palestine, Iraq, Afghanistan. Will we ever see someone like Major General Holitz or Donald Rumsfeld ever stand trial for war crimes? How big are the stepping stones?
It's always outside of America.
To what? A stepping stone towards building a permanent institution like the ICC, yes. All of these institutions are an important stepping stone. And that's why we're able to have the ICC. So that's number one. Is it a stepping stone as a deterrent to people who commit these terrible crimes, whether it is the major players, military people that you speak of, or just the simple militia people that are operating in the jungles of Africa or in the jungles of Colombia? The answer is no. Just to give you an idea, in a study that the Paul Human Rights Law Institute did, Between 1948 and 1998, we were able to document 251 conflicts in the world. And the low estimate of the number of people killed was 70 million. The high estimate was 170 million. If you took the low estimate, 70 million people, it is more than cumulatively the victims of World War I and II put together. Now, if you look at the record of impunity, you will find that more than 99% of those who engaged in these crimes for that entire period of time have benefited from impunity. Now, you've got to think for a minute, what does that do to deterrence? And so you have to realize that so long as you create institutions in The Hague that will deal with some of the senior leaders, you're not going to produce deterrence in the field. I have one more example that I wanted to answer to what Jerome said and what some of you said about the influence of politics. One of the major charges at the Nuremberg Tribunal was a charge brought against Germany for having killed in the Katyn forest 12,000 Polish officers. And this case was prosecuted by a prosecutor from the USSR. And Russia made a big to-do of it because it was very important to show not only that this took place, but to cover up on the fact that there was a secret agreement, the Molotov-von Ribbentrop agreement between Germany and Russia, that they would split up Poland between them. And that agreement no way figures in the records of Nuremberg, and the Russians were able to prosecute and convict the two senior German officers, the Commander-in-Chief, General Keitel and General Jodls, of that crime. To date, that record at Nuremberg is unchanged, even though it has been proven that this was a hoax. These 12,000 officers had been killed by the USSR. They pinned the blame on the Germans. That historic record has not changed to date. To date, not a single word has been said about the estimated 20 to 40 million people that have been killed since Lenin, Marx, Beria, and all of the purges of the USSR and the communist regime. Why aren't these victims worthy of at least somebody raising the question and saying, why are we turning the page?
You know, I did want to mention the legal precedents that were set on the punishment of sexual violence in wartime. Are there are there other specific, that and other specific legal precedents that the ICT really brought up? You know, even torture. I mean, the Bush administration did squirm on torture a bit when they're in their backroom discussions, I think. But
I'm not really sure that. I think this was more the media impact of it than anything else. The first time the issue of rape in conflict occurred was at Nuremberg, and it was brought by the French prosecutor. And in fact, I read a portion of the transcript which stuck in my mind because it hit me so much. The prosecutor couldn't get himself to use the word rape, and he was saying in French, this terrible crime against women, which is unspeakable. I can't even utter the word of it. It's almost verbatim. But this was the second time. Really the first time it came up was in the 1919 Commission report of World War I, when there was some massive rapes in a number of cities in Belgium, particularly in Lille and Roubaix. And that was the first time it came up. And of course, in the first Balkan War report in 1915. So you have a lot of that came up. Yugoslavia Tribunal got a lot of good publicity out of it, but numerically very limited. Barely scratched the surface.
Judge?
Yeah, I just want to follow up on that. The Yugoslav Tribunal found rape to be torture. And actually, my experience has been that that has had a phenomenal effect on people in Yugoslavia, in Bosnia. My legal assistants, who are women who work on these cases all the time, this was a huge milestone. And we have had discussions. We meet as a court at what we call reference meetings, where we try to resolve what the new law should be and how we should interpret it. And in those discussions, they are very moving discussions. And we have several older European judges who just simply who simply didn't get it at first. And it was amazing to watch our young women legal assistants explaining it to them. So my experience has been that it has had huge ramifications in terms of how people have received that. What its legal effect is ultimately going to be, I don't know, because rape as a crime against humanity is equal to and punishable as in the same way that torture is. But in terms of recognizing the suffering of women as victims of this war, it really has had a lot of significance. In terms of other sort of precedential issues, one of the downsides is that war criminals have learned a lot from previous war crimes cases. The Nuremberg tribunals depended heavily on documentary evidence to convict Nazi war criminals. The perpetrators of war crimes in Yugoslavia learned not to leave many documents behind, which has been a tremendous impediment in terms of prosecution of those cases. And what you hear over and over again from the witnesses in whose custody those documents would have been is, oh, well, it was a chaotic time, there weren't really any documents. Well, we all know there were documents, but somebody knew to get rid of those documents. Somebody else knew to falsify documents. There are forged documents, there are false documents that we're getting by way of the ICTY that have been gathered right after the war. So there are lessons learned that have actually made it more difficult to prosecute war crimes cases. On the other hand, on the issue of the big fish versus the little fish, this is a discussion that we have frequently. Our prosecutors have to come up with a policy because we're looking at over 2,200 cases. The estimate is that we have to try these cases within the next 10 years because we are not going to have enough witnesses who will survive after that to bring these people to justice. So decisions will have to be made. And the question of do you prosecute the highest level, the middle level, or the people on the ground is a constant question that's coming up. And I think what the answer is that you take a cross-section of each, because it is almost more important to the people who are the victims to have the people who actually perpetrated the crimes brought to justice publicly. And one of the advantages, as well as the disadvantages, of trying these cases in Bosnia is that every night on television, we're the lead story, for better or worse. Unfortunately, I don't know what they're saying, but we're there. It's on the news. I turn on the television and there I am. It's critically important, I think, that the people who pulled the trigger, who did the rapes, are seen by the victims to be brought to justice, as well as those who may have been behind the planning or the ordering of it. So we can't get everybody, but I think it's important that we get a cross-section of those people.
We do have, I want to just blend a few procedural questions. There are some people who are curious about how the ICTY works with the court in Bosnia. How do you get the cases? Who decides what court gets what cases? How does that work? There was another question about how legitimate the verdict is. If the court has two internationals and a domestic judge, do people really end up respecting that as why is that not an international conspiracy? And what about, and there was a question also about the Serbia and Croatia national courts, and you know, do they end up prosecuting people without international judges? What happens? Isn't it fun to get 3 questions at once, 3 or 4?
Okay, I'm sorry, what was the first one again?
The first one, how do you get the cases?
Okay.
Who does the split?
Yeah, the part of the termination of the ICTY, part of their policy is to transfer cases that have already been indicted at the ICTY back to the countries where the crimes were allegedly committed. We have gotten, that's not a great many cases. We have gotten the most, we've gotten 6. Croatia has gotten 2. The other case, there's another level of cases which are investigated and would go to indictment at the ICTY. They're called level 2 cases. We have 45 or so of those that are coming to us directly from the ICTY. Then there's another whole category of cases that were taken away from the local courts, reviewed by the Office of the Prosecutor, and determined to be meritorious, and we have about 875 of those. The rest of the 2,200 whatever cases are cases that have been brought forward by our own prosecutors or prosecutors in the entities.
That 800 number is big.
That's a big number, I know. Well, so is the 2,200 number, which is the total number.
Yeah, so you end up doing a lot more volume.
Yeah, well, and we can't, obviously. We have 5 panels that can only
Sorry, my understanding
so
is that there are between 16 and 18,000 potential cases in Bosnia.
That's probably true, but of those 4 categories that have been investigated, there's over 2,200 that could legitimately be brought tomorrow, but can't because of the limitations on the resources. The second question?
Serbia and Croatia's national courts, I mean, they're prosecuting people with international judges, without international judges?
No, they aren't, but they also don't have the volume of cases that we have, and Macedonia, the Macedonian judges that are going to be doing that have 3 cases. They've come to our court, and we've sent our judges to Macedonia to do trainings with those judges. Serbia and Croatia, Gordona knows more than I do about the number of cases that they're prosecuting. And then your third question was, do people
see it as legitimate if there's 2 internationals?
Well, you have to balance. I have not heard the complaint that the internationals make it illegitimate.
Because the nature of Bosnia is such. The nature of the society is such that it has these free ethnic groups. So international judges give that kind of authority and balance that they would not support one or the other group. That's in that sense more legitimate than it would be in other countries.
Right.
Country specific.
And we are going now, at the end of this year, we'll go to 1 international judge and 2 national judges. But we will keep the other balance on the appeal panel so that the ultimate oversight will be able to respond to any allegations of ethnic bias.
All right. Thanks for all the questions. I'm sorry I didn't get to all of them. There were lots of good ones. And thanks to our panelists. The Beyond the World series, you can see Beyond the Headline series. You can see more of the what's the upcoming programs are. They're on the web. And now Sharif has something coming up at the Harold Washington Library on the International Criminal Court. If you're interested, it's April 24th. 25th. There is a gigantic program on the International Criminal Court on April 25th. Thank you all for coming, and nice talking with you. Thanks for